your second insight, I think.
Just to finish a point, my lords, on the this unhappy dissolution of the Akhmedova marriage is just to make the point that my learned friend, although he doesn't address this case, hasn't addressed it orally, he has accepted in his written case at paragraph 173, page 133 of the bundle, just for your lordship's reference, that he accepts that Akhmedova must have been wrongly decided if he is correct on this appeal. And so the protective purpose that Mrs. Justice Gwyneth Knowles had identified would be defeated on his construction of 423. The second insight is the contrast to be drawn with an equivalent provision for avoidance of dispositions of property in the Matrimonial Causes Act. I may just begin by showing you how this arose in the Akhmedova decision. And so you can see at page 846 of the bundle, at paragraph 61, there are references, there's a subheading, 2/3 of the way down, claims against Councillor and Solbado. And for those claims which do not relate to the Moscow property, the transferor, Hotor, was a nominee. We can get that from the glossary. Was a nominee, and from the beginning of the judgment, a nominee for the husband. So in those cases, those claims would not engage the issue before the court today. And so for those cases, parallel claims, we'll come to the wording of the Matrimonial Causes Act in a moment. For those cases, parallel claims were brought under 423 and under the Matrimonial Act. They could do that, and we'll see why, because the husband had the beneficial interest. And that wasn't pursued vis-a-vis the Moscow, or the Solyanka service shares, the Moscow property claim. So if I can take you to the wording of the other act, it's at page 855 of the bundle. So within the Akhmedova decision, it's set out. Paragraph 107. And so you can see the heading, avoidance of transactions intended to prevent or reduce financial relief. And just by way of summary, this is a provision effectively to stop spouses disposing of their property either before or to frustrate a financial relief award. You can see the obvious relevance to the Akhmedova situation. You can see as at paragraph or subparagraph 2A, just by way of the structure, 2A is for injunctive relief, and it's 2B with which we're with 2B and C, which we're concerned about. And they concern setting aside an actual disposition. The words I want to highlight, and there's a few of them for your lordships, and for my lady, is the expression, first of all, the use of disposition. And that's defined then at subsection 6 at the bottom. The word disposition will be familiar language to the court now, after my learned leader's submissions this morning by reference to section 127 and 284 of the Insolvency Act. And then we also note the way in which it is tethered to the other party. That is to say, if you look at B, 2B, it is satisfied that the other party, is to say the spouse, or whoever it is, made a reviewable disposition. So again, it's the person, if you like, conducting the act of transfer. So there's two ways in which this is distinct, and the wording will be contrasted. The first is the disposition, that is the nature of the act involved, and secondly, who it is that has to have done it. And so we can see in this act, which preceded the 1986 Insolvency Act by some 13 years, used much narrower language. And that's why when we get to the learned judge at page 857 of the bundle, at paragraph 113, when she her ladyship distinguishes between 423 and 37 of that act, there's various ways in which there's different issues about burden of proof, there's different issues about undervalue isn't relevant as long as you give some value, things like that. But at paragraph E, you can see how her ladyship contrasts section 37 being by reference to a disposition by the spouse of his or her property, whereas section 423 utilizes the much more flexible language of transaction. And on that first aspect of that, on section 37 and its scope, and that's not a initial finding by her ladyship, that's settled law, but that's the scope of section 37. Yes, and you can see reading on there that the transaction, at the end, the transaction can include informal arrangements and procuring acts by third parties. So the language of 423 accommodates that, whereas the language of Section 37 Matrimonial Causes Act doesn't accommodate that. And so this is the insight is it's quite useful to have a reference point when engaging in statutory interpretation to, if you like, anchor the court when it's looking at how wide or otherwise 423 is, by looking at how relatively wide it is compared to provisions which are otherwise engaged in a factual circumstance. It's not in the bundle, but just for your Lordship's reference, and I have a copy here, if necessary, but the authority to the effect of this narrower scope of Section 37 is a case called Reed or AD and Panzone, or Panzone, at paragraph 86 to 88, but we can provide a copy of that, but I don't imagine that's controversial. So that was the second insight, was just, and then we can see in the, rather when it comes to the relief then, in respect of, well, as I've showed, the relief is granted on the beneficially owned property on both bases, on both grounds, on Section 37 and 423, whereas on the Solyanka service shares and that transaction the husband procured is only 423. So that's the second insight that we get from the case. The third is the one that my Lady Rose had happened upon. And it's the question of, well, what could have been done with these corporate assets? Why were they within reach, such that Section 423 is engaged because now they're out of reach? So My learned leader took you to a case, and I want to take explaining that, and this is it working in practice. So the first reference is at paragraph 293. That's at 887 of the bundle. And there, Her Ladyship explains what could have been done. The wife could have taken steps to enforce her judgment against the interest in Cyprus, for example, by obtaining a charging order over the husband's interest in Sunningdale and or an equitable receiver over Sunningdale, as she has now done. But as we sadly come to find out, she was too late in that. And so we see at paragraph, again, another reference to this at paragraph 319. At page 891. There's again reference in the middle of that paragraph about the wife obtaining a charging order and the steps, such steps, an interim receiver over the Cypriot company. And those steps were intended to ensure that whatever the outcome of some Russian litigation, the shares in Solyanka service would be available to the wife for enforcement. And then we come on finally to the paragraph that my lady had identified at page 893 of the bundle, paragraph 330, explaining again that the wife could have obtained a charging order and appointed a receiver over the assets of Sunningdale. She did precisely that, but she was too late because the husband had already managed to move the assets again. And so this is what, this is the very mischief.
It's the next sentence that's, I think, is key.
Yes, and therefore rendering his interest in Sunningdale worthless by causing this divesting of the interest in Solyanka service. My lady is ahead of me again. The husband intentionally prejudiced the wife's ability to enforce her judgment, and that's what's achieved pending a successful 423 application. So the fourth insight I want to present to the court is related to the policy concerns which emerge from all of this. Two references, I won't turn them up, but just which ground what happens here, contextualizes it. Paragraph 6 of this judgment, page 837. What was described by the learned judge was the wife being a victim of a series of schemes designed to put every penny of the husband's wealth beyond her reach. And particularly then on paragraph 10 on the next page, 838, in respect of this particular transaction, what had been thrown up was a formidable smokescreen by the debtor's husband's actions. But what's really interesting about this case in this regard, in this series of schemes, feeds into what my learned leader was mentioning earlier about the evolution of thinking on the part of not so much the man on the Clapham omnibus, but maybe the man on the Monegasque yacht, as to how to render yourself Section 423 proof. This was actually the husband's second attempt to put the value of the Moscow property of the Solyanka service shares beyond the wife's reach. If I can take your lordships to and your ladyship to page 839 of the bundle. And what we can see there, closer to the beginning of the judgment, paragraph 26 and 27, is actually before this claim, that claim, subject of this judgment, was decided. The husband had previously transferred his beneficial interest in the Cypriot shares into a Dear Me trust Bermudan trust where he was beneficiary, settlor, or protector, everything really. And that was set aside under a 423 claim by Mr. Justice Haddon Cave as part of the main judgment. And so what we see is Farhad Akhmedov realises, well, it's not good enough just to transfer away Section 4, the beneficial interest in the shares I own. I've got to go and better next time if I want to defeat my wife's ability to enforce against and ultimately get the value of this Moscow property. I'll leave the shares in my own hands, and what I'll do instead is I'll procure that my company transfers out the Solyanka service shares and Cypriot shares left in situ for the wife to enforce against, but ultimately with all the value having been stripped out of them. So this is a particularly stark example of working around what my learned friend would have as the narrow, constricted Section 423. And my Lord Stevens queried, and of course, as my Lord Hodge clarified, were assumed facts in our case. But in this case, the Akhmedova case, this would have been a striking injustice if the court were able to, if the judgment debtor were able to take back the shares after Mr. Justice Haddon Cave's first ruling on Section 423, and then achieve precisely the result he wanted to achieve the first time around by this other mechanism, which he would be able to do on my learned friend's construction of it. And my learned friend says, well, the colloquy with Lord Stevens, well, this is a matter for Parliament to deal with any potential injustice. Well, first of all, we would say it's usually an argument made by parties who are countering or meeting an argument where somebody else, on the other side, are trying to expand a narrowly drafted statute to meet a gap. This is an argument which is being run by my learned friend to try to narrow a widely drafted statute. And also this argument about parliamentary, going back to Parliament to fill a lacuna. Our analysis doesn't really work because my learned friend's case is that Parliament deliberately created this system, deliberately created this gap in order to fulfill all the various functions he says in his written case it should fulfill, re-preferences, a coherent system in the 1986 Act. So as far as my learned friend is concerned, Parliament has already spoken and is already, if he's correct, already happy with this gap. So I don't see that as an answer. Well, those are the four, and my lady, are the four insights I wanted to draw from the Akhmedova case. If I can then turn just to a question which was raised, subject to any questions the court may have on this case. I may turn to a query from Lord Richards about discretion. It was the case of Paramount Airways. I'll actually turn it up because it's page 3290 of the bundle, and it's a Court of Appeal decision, and it's the Vice Chancellor Nichols, I believe. And you can see under the subheading, this is 3290, the court's discretion. In that paragraph beginning from F, and just by way of reference, this was a case about the extraterritorial effect of 238. And the argument was being said by the other side, well, look, you could create all kinds of difficulties if you allow 238 to have extraterritorial effect. And the answer which was given by the Vice Chancellor was that, well, actually, although 238 and 339 and the preference, I think the preference provisions as well, use the word shall, in contrast to 432, there is also a discretion, because, of course, in that case, judicially construed, shall meant making an order can mean making an order for no order. And so there was that discretion. But the reason I turned this up specifically, instead of giving your lordships just a cross-reference, is what we get is, it feeds into my learned leader's point about this being a discretionary, which the Court of Appeal adopted, this being a discretionary regime, 423. And if one thinks about it, the 4231 and 4233 criteria, they are really in the nature of gateways that unlock the court's discretion. And so every time a learned friend puts up a hypothetical of some awful outcome, I think there's reference, for example, in his written case to somebody would have an unanswerable 339 case. There's no such thing as an unanswerable 339 or 423 case. And what's described there by the Court of Appeal is a regime which has safeguards built into it. And one of those safeguards is the discretion. Even in that case was 238, and even with shall. So we submit that that actually serves as a very good answer to a lot of problems. If there are any edge cases or difficult to reconcile scenarios, they would be dealt with there. It's been recognised that the function is as a safeguard of discretion. My Lords, I only have some short points to make about Fekins and what we draw from it. It's simply that an overall arrangement implemented by way of an act of transfer under it, or part of it, or caused by it, procured by it, that can be a transaction for the purposes of Section 423. And the second proposition we draw from it is that the debtor, who of course has to be party to the transaction, doesn't have to undertake personally any act of transfer. That's what we take from Fekins. General propositions, the stepping stones, I think my learned leader described it, and we've used that phrase before, towards where we need to get to today. And we submit that there's no need for a detailed parsing of the particular complex transaction which was at issue in Fekins, in that case, in order to sort of somehow reverse engineer it or map it across to the far more straightforward case that we're dealing with here. We simply need to draw out the propositions I've just referred to. So, my Lord, then...
Would you agree with how it was analysed by Mrs. Justice Knowles in Akhmedova, paragraph 329? So she relied on Fekins in her analysis of the transaction, didn't she?
Yes, and so she was relying on Fekins for the purpose, so yes, to answer your Lordship directly, right. Is that what is happening there is the husband was not the proximate, if you are, not the transferor. And so, my lady, when you look at what the husband did, he didn't, it wasn't his beneficially owned asset, so he wasn't transferring the Solyanka service shares. But yet, as we learn from what you draw from Fekins, is that he, or that you can be party to a transaction even though you are not the transferor. And that's what she's relying on, I submit, on Fekins at that paragraph 3.
Can you just give me the reference to that paragraph?
That's
893. 893.
Paragraph 893.
Page 893.
Page 893, paragraph 329.
329.
Thank you.
He says the case where the person brought about the sale of the farm through the medium of the mortgagee. Is that the way you analyse it?
I think the medium of the mortgagee is the words that were used by Lord Justice Jonathan Parker, and I think my lady was had happened upon it. But the arrangement between Fekins and Hawkins, and the sale, of course, and I think this is the point is being drawn out here, is the sale was effected by NatWest using its power as first mortgagee. It wasn't him doing it wasn't Fekins who was the seller if you like. It may have been his asset, but he wasn't doing the...
But he was the beneficial owner of the farm.
He was the beneficial owner of the farm. And so what I'm drawing out from Feakins, my lady, are the stepping stones towards where we need to go to today. I'm not suggesting that... I'm not relying on Feakins as saying Feakins provides the answer and you have to follow Feakins, and there we are. That doesn't undermine our position, my lady, that happened to be a fact in that case. The next issue I want to deal with briefly is a matter close to the hearts of us on this side of the bench, and that is that of barristers' fees. And in the case of Gwyneth and George, this was a case where the Court of Appeal was asked, it's at page 2176 of the bundle, where the Court of Appeal was asked to consider whether barristers' fees, this is pre-2013 when they were honoraria, should count as property for the purposes of the Insolvency Act. And what is found there, and it's as easy to take it from the headnote, is that although in the nature of an honoraria, they could be property within the meaning of the Insolvency Act, because there were various mechanisms in play that would mean that realistically a barrister would get paid. For example, you could report the solicitor to put them on a blacklist for of the Bar Council. The solicitors themselves might feel themselves under obligation to pay, etc. And so what we draw from this case is that when one looks at the Insolvency Act, one is not always looking at proprietary interests. And so when my learned friend formulated his case at para 6.1 of his written case, he referred to transfer of property of which the debtor had a beneficial interest. One thing which I noted when my learned friend opened his propositions in oral opening, having presumably read Gwyneth and George, is he then pivoted to a case of when the debtor transfers something of value belonging to him. And so what we have is again another example, as with the bank transfers, of my learned friend's shifting of his case to meet obvious cases where Section 423, or indeed other provisions of the Insolvency Act, are properly engaged. And it's quite incongruous to be coming along and to support a submission that wide statutory language has some inherent implicit restriction if my learned friend finds it so difficult to identify what that restriction should be, and it keeps shifting. I want to correct one point in my written case, our written case, my lords, my lady. It's at page para 105 and 104 of our case. We refer to this as a Section 339 case. Actually, if you, it's not in the bundle, but if you go back to the High Court decision, it's not actually a 339 case. It's a case on where it was a claim in tort of conversion for the barrister's fees and a claim of unjust enrichment. It was against a barrister and his practice manager. But the point still stands that in that case you could only, the claimant, the trustee in bankruptcy, would only have standing to bring the claim in tort if the property was vested in him. So the court had to determine were barrister's fees vested in the trustee in bankruptcy, and that's where we get to how we get to the
the right to the fees.
The rights to the fees, yes. And so, well, actually, my lady, that's a really interesting point. The use of the word rights. There is actually no right to the fees, and that was precisely the point which was made by the barrister and his practice manager, was that actually there is no right to these, no proprietary interest, beneficial, legal, or otherwise. It's conceptually out with all of that framework.
Entitlement, I think, is what they use. They use the word entitlement.
Entitlement. So where we end up where I'm going with this is that in order to accommodate that a Section 423 claim could catch and should catch somebody putting barrister's honoraria beyond the reach of a creditor, my learned friend, as with bank transfers, has to reformulate his proposition to remove references to a beneficial transfer of a beneficial interest, and now has to refer to it, as he did in opening, as a transfer of something of value belonging to...
This is quite... Sorry, so the let me get this right. This case turns on the definition of property.
Yes, my lord.
In section 436.
Yes, my lord.
Because if it was property, within that definition, it vested in the trustee in bankruptcy.
Precisely. And therefore the trustee in bankruptcy would be able to maintain a claim in conversion.
I follow that.
Yeah.
Though I doubt it was conversion. But how does it impact on 423?
So I make the point.
Well, presumably a barrister is a debtor. A barrister, a debtor.
Barrister
is a debtor. He gives away his fees.
Yes, exactly. So
and he's got no beneficial interest, no right to those fees, but it's
yes, and it's exactly. And if my learned friend's written case at 6.1 says it has to be a transfer of beneficial interest, well then barrister's fees are out with it. But now they're within what he has had to expand his case to in oral submissions, something of value belonging in the more loose, woolly way, if you like, that has been approved in Gwinnett and George. And therefore, it's an example, and where it ultimately leads to submission is that if you can't draw the line properly, and if you can't draw the line, it's always shifting, it indicates that there's no obvious parliamentary intent that there is such a line at all. My learned leader, I won't go back.
Otherwise, they'd have to say this was wrongly decided, and they're not prepared to say that.
So they shift the line again. And so what...
so the phrase is value. What's the phrase?
It was my learned friend's proposition.
Yes, it was originally assets beneficially owned.
Beneficial interest was the word used in 6.1.
Cause something valuable that belonged to him to be transferred.
Yes. And now, on that formulation... On that formulation, it would come within it. Gwyneth and George would come within it. So that's Gwyneth and George, and why we say it affects the shifting, or demonstrates the shifting sands. There's a couple of authorities which I will, which my learned friend hadn't developed orally, which he said supported the proposition of this requirement. And I'll only take your lordships and your ladyship to one of them, just because actually the others are, if you like, inconsequential and irrelevant, but this actually is an example of a case which is actually in our favour, arbiter. It's a case of Brookman Home. And that's at page 1378 of the bundle. And 1378, and it's a Deputy High Court judge decision, and it's a 238 claim, and it's a claim in which There were two companies, a parent and a subsidiary, in which they had common directors and a common bank account. So quite a lot for the trial judge to sort out factually there. What the trial judge found, and there was a 238 claim because payments were made out to the individuals who held directorships. And the claim was brought by the trustee in bankruptcy, the liquidator of the parent company, and said, these are 238 claims, it's our money, the parent company's money, which has been sent out to these two individuals. And on the facts of the case, the judge decided that actually the money belonged to the subsidiary company, and therefore dismissed the 238 claim. And I understand my learned friend relies on that as authority, that you have to have a beneficial interest in an asset in order to come within.
The parent company brought claims against the recipients of the money.
The liquidators of the parent company, yes, against the recipients. And the key paragraph is at paragraph 49, which is 1388 of the bundle. And what is found there is the judge says, referring to the 238 claim, says halfway through, this is my learned friend relies on, if, as I have found, the payments were made with 1877's money, that's the subsidiary's money, so the judge having found the money in the bank account belonged to the subsidiary, not the company's, that's the parent company's, and the company had no independent rights of disposition, this precludes a claim based on section 238. But as your ladyship has been enjoining me to do in these submissions, read further, if I can ask the court to read a little further. The obiter point is in our favour. The judge goes on to say there's also no room in the present case for a claim based on the proposition that the company might have promised to procure that the payments would have been made. Going on then to reference the facts whereby the directors were acting qua director of the subsidiary company and not the parent company. And then final two lines and the final sentence, it follows that the company was not a party to the material transactions in the sense required. And so the point being that if it had been pleaded and if it had been shown that notwithstanding that the money belonged to the subsidiary 1877, the judge was at least obiter considering the possibility that a 238 claim could be made out by the way of procuring. Didn't need to go into it because on the facts there wasn't that. So that's actually a case that we say supports us. There are other cases which are of less consequence. The Lemos and Lemos decision wasn't developed orally by my learned friend, and we'll just rely on a written case for what is said there.
Yes, in Brookham House, the Deputy High Court Judge, in the passage you refers to, I think it's Lord Justice Kitchen's judgment in Ray Ovenden.
Yes, the Hunt and Hosking. We've had one of the debates in this case is how to refer to that particular case, but that's the Hunt and Hosking case that we've been batting around. Yeah. But yeah, exactly, and so has in mind exactly what we're where it is said at the beginning, this precludes a claim based on 238. It precludes the claim on the facts of this case as pleaded and advanced in that particular case. It might have made uncomfortable reading for the whoever may have been that this alternative case wasn't pursued. But anyway, there we are. That's what we take from can be taken from Brookman home. My lords, unless there's anything any questions from the court? Not, I think.
Thank you very much, Mr. Delahanty. Mr. Warrants.
Thank you, my Lord.
You have 15 minutes.
Of course. I'm obviously anxious to answer any questions the panel has for me, but subject to that, I propose, first of all, to give a couple of cross-references that I omitted to give yesterday, and then develop, I think, 4 short points of reply. Firstly, on the cross-references, I think I said on a number of occasions that there was a passage in Feakins that showed that the ultimate decision to exercise the power of sale was the mortgagees, and the words that were found in the first instance judgment were, the fact remains that it was the bank which made its own decision to sell to Miss Hawkins. And I'll just give you the reference to where that can be found. So it first appears at page 1961 of the bundle, letter G, quoting paragraph 15 of the first instance judgment. And then that topic is raised again at paragraph 49, which is on page 1969. Just to make good the point that there's no need to show that you've suborned anybody's will. Second point on which I intended to give a reference was there was some discussion yesterday as to whether it was necessary to show that the agreement or arrangement was otherwise lawful. And an example of a situation in which an agreement or arrangement was unlawful for another reason but still found to be conceptually capable of being an arrangement is provided by the Section 238 case of Bruin Dolphin. The head note is sufficient. 3448E refers to one component of the linked transaction in that case was the entering into of a sublease agreement, which was actually made in breach of covenant in the main lease. So there was a separate illegality. On the facts, it turned out there was still an undervalue, but conceptually, even though one aspect of the agreement, the linked agreement, was itself unlawful for another reason, it was still capable for those purposes of being an agreement or arrangement within the requisite sense. If I can just deal briefly, first of all, with Gwinnett. There's been no pivot in my case. Paragraph 6.1 of our written case expressly refers to the word property. I always intended the word property to have its Insolvency Act meaning. It causes me no difficulty.
So, what page number is that?
It's page 100 of the bundle, and it's paragraph 6.1. There was no intent yesterday in the way that I formulated my propositions to shift my case. I used the word property in its full broad sense as it has in the Insolvency Act 1986.
Did you use property in the sense of beneficial ownership?
Well,
does it capture the fees of a barrister?
Well, it does, my lord, in the sense that it's covered in the Insolvency Act 1986. They own that property.
Sorry, but the word property, I don't think is used in section 423, is it?
I entirely accept that, my lord.
Because you're, as it were, construing, in one sense, one can say you're inserting some words. You might not want to put it that way. But I think the point that Gwinnett raises is, well, exactly what words are we inserting?
And, my lord, the critical point there is that Lord Justice Hoffman was the one who used the word property in Clarkson. He expressly said that the purpose of the section...
That was a bankruptcy case.
It was, my lord.
Which this would not necessarily be.
And I accept...
That's the difficulty.
Yes. But, my lord, in my submission, when Lord Justice Hoffman was addressing that particular bit of his judgment, and we need not go back over it, that when he formulated the test as what property have these bankrupts have they given it away, he was talking about the TUV test. He was analysing, in that case, 3393A, which is the equivalent of 4231A.
But he was, anyway. I mean, we want to be clear, I think, as to what you say is the term to be introduced into, or the words, if you like, to be read into 423.
Well, I say the qualification is that there has to be some giving away or transfer of property in its Insolvency Act sense.
Sorry, let me pick. So,
And what do you mean by
involve
that?
a giving away?
A giving away, using Lord Justice Hoffman's phrase, or a transfer
Giving away or transfer.
of property.
Hold on. Of property as defined in section 436.
With its full broad scope in 436.
As defined in section 436.
And unless my learned friend is going to say that Gwinnett is authority for the proposition that somehow property in 436 makes the property of a company the property of its shareholder, which I don't think he's saying,
No.
then in my submission, Gwinnett gets him nowhere.
You say giving away or transfer. Can I just ask you the point that I was raising this morning? Do you include in giving away or transfer a waiver or renunciation?
My Lord, I'm very glad you asked me that. We did address this in our written case. I'll just direct you to the relevant part.
Thank you.
We referred to, I think actually this was raised in the Court of Appeal below as well, and we've mentioned that. It's paragraphs 224 to 228 of our written case, starts on page 143. Your Lordship may be surprised to know that this was a controversial topic. This was a controversial topic even under section 127, perhaps still remains to this day. In Akers and Samba...
Well, what's the answer to the question here? Because your time is limited.
I am happy for present purposes to accept that the waiver of a cause of action can fall within the scope of the provision. The reason I do so is by analogy with the reasoning used in Akers and Samba, and the references are in this passage, my Lord.
Thank you.
And I say it causes me no difficulty.
So you move away from the word transfer then?
Well, my Lord, I accept that the reasoning that was applied in Akers and Samba in the context of section 127 is probably very persuasive and can be applied by analogy to section 423, but with this qualification that what it doesn't do is extend as far as saying causing a company to part with its property in some way would be included. That certainly
I mean, to be fair to you, and the way you put it in paragraph 6, this is a case of a transfer.
Yes.
It's not a case of a waiver or renunciation.
Yes, my Lord.
But at any rate, your position is that it isn't, it's not actually as a matter of law limited to transfer.
Not in that entirely literal sense, no, my Lord.
I'm sure you're rowing back a bit now. No. A transfer, because something goes from A to B.
I accept that. For present purposes, I am happy to accept that. Yeah. The surrender of a cause of action, a compromise of cause of action, could fall within 423. I'm not so doctrinaire as to say that it can't extend that far, but what I say is it doesn't extend to the circumstances of the present case.
And the bank transfer and the guarantee?
Bank transfer I deal with by the tracing point, which I introduced by reference to section 425(1)(b). Guarantee I have no difficulty with. It's always been part of the case formulated, certainly before this court, and it was actually orally before the Court of Appeal, though I accept not in my written skeleton, that I accept the incurring of a liability is included.
How do you trace something if you haven't got a right to trace? You have to first of all establish that you fall within section 423 before you can trace anything.
Well, my Lord, to go back to what I said about 425(1)(b, what 425(1)(b explicitly contemplates is that the court can look at the application of money that has been applied or the proceeds of something that has been applied. In my submission, that is apt to capture the situation of a bank transfer, and so it's expressly contemplated by the statute that there can be something that I would describe as a tracing exercise.
Aren't you making it too complicated for yourself? Well, once you've accepted that a waiver or surrender or renunciation is within the purview of 423, then so is a bank transfer, because the effect of instructing your bank to transfer money to the payee's bank account is that you have reduced or released your claim against your bank.
Yes.
I bet just fits. You don't need the complications of tracing, do you?
My Lord may well be right. That may well be a sufficient explanation for it. I have my tracing explanation as well, if that's not good enough. But none of it shows that a diminution in the value of the shares falls within section 423. anxious to answer the question about discretion, which I know my Lord Stevens has raised on a number of occasions, and I accept it's an important point. Now that the bank has made clear that the focus of its case is on a diminution of the value of the shares rather than being focused on the ability to control the company, I want to make this point good by reference to the example of the grant of a lease. The reason I say that is, obviously I explained yesterday about the problem of marriage value, that in a great number of leases, probably most of them, certainly ones that aren't very long leases, whenever a freeholder grants a lease, you will have the creation of marriage value, which the starting point will be a split 50-50 between the landlord and the tenant. And as I explained yesterday, the 50% of the marriage value which is allocated to the landlord takes effect economically as a reduction in the value of the freehold. Now, if the bank's case is right, then it has this extraordinary consequence, that pretty much all leases are transactions at an undervalue. The reason being that the ordinary economic consequence of the creation of the marriage value means there is a diminution in the value of the property which belongs to the debtor, namely his freehold reversion. That's the effect of the marriage value, the 50% that is allocated to him.
All grants, all sales of the reversion, sorry.
Well, my point is this. If you have a starting point where you have a...
No, I understand, but just what was the last bit you said? All something is a sale as a transfer at an undervalue.
All grants of leases, or a very substantial proportion of the grants of situations in which a lease is granted by a freeholder, will, on the bank's case, automatically be transactions at an undervalue. Because once a marriage value is created, there will, by definition, be a diminution in the value of the freehold, which will not be paid for by the tenant.
If you own a freehold and you grant, let's say, a long lease of a 99-year lease of the freehold at a premium plus a ground rent, I mean, unless you're badly advised, the value of what you receive will be at least the value of the unencumbered freehold. Well, at that point, I mean, thereafter, of course, it may change considerably depending on all sorts of other factors, but at that moment there should not be any undervalue.
My Lord, I'm afraid that's not right. Can I give references to two cases that explain this and deal with this exact problem? One is Agricultural Mortgage Company in Woodward, and the specific passage is at pages 787 to 788.
Agricultural mortgage and Woodward.
And Woodward is discussed in the Court of Appeal at page 787 to 788. And the point was left open. And it reared its head again, and it's specifically discussed at first instance in Nat West and Jones by Mr. Justice Newberger, as he then was, at paragraph 75 onwards, which starts at page 3140.
Is that affected at all by the Court of Appeal's decision?
The Court of Appeal didn't
deal
with
case.
The Court of Appeal in that case didn't deal with that issue because it didn't come back up on appeal.
But even if actually there is a diminution in value of the debtor's freehold interest, as it were, it matters not, because it's got to be done for a particular purpose, and thereafter you've got to get over the hurdle of a discretion.
Well, first of all, my Lord, under 238 or 339, there would be no need to establish the purpose at all. We're dealing with the extraordinary consequence that any individual company that grants a lease is entering into a transaction at an undervalue. And
So
if
then the original debtor, if the debtor owns the freehold himself and he creates a lease.
Yes. That's exactly the situation I'm contemplating, my lady. Whether we're dealing with a debtor under 423, an individual who becomes bankrupt for 339, or a company that becomes insolvent under 238. In each case, let's assume they are the freeholder to start with and they grant a lease. The consequence of the bank's case is that if marriage value is created, we will have a situation in which there is a transaction at an undervalue.
If marriage value is created.
By which I mean to say that the ordinary consequence of granting a lease is the economic consequence I described yesterday and discussed in the...
Well, I can see marriage value being analysed when you come to try to sell your premises with vacant possession.
Yes.
But when you actually enter into the lease, it's not a concept I come across then.
No.
My Lord, it may seem surprising, but it's not entirely virgin territory. It was specifically discussed in Woodward and NatWest and Jones.
It's certainly a bizarre result.
Yes.
I mean, we need, even before we get to discretion, before we get to motive, purpose rather, the notion that in the transaction I've described, there's a transaction at an undervalue seems absolutely bizarre.
My Lord, that was exactly the thing that troubled the Court of Appeal in Woodward and Mr Justice Newberger, as he then was in NatWest and Jones, but wasn't determined. And that's why I invite the Court to look at those passages. But the reason why it then comes into discretion is if we accept for the time being the premise that on the bank's case that would be a transaction at an undervalue.
Why wouldn't it be a transaction at an undervalue on your case as well?
The reason why it wouldn't be a transaction at an undervalue on my case is I don't take into account the mere detriment on the side of the landlord. I exclude detriment from what is termed consideration, whereas the bank's whole case is a diminution in the value of something that is retained as a result of the transaction. So that's the fundamental difference. And applied to leases, as I say, it creates this very troubling consequence that the vast majority of leases are going to be transactions at an undervalue, and more to the point, that the tenant may have paid an absolutely fair price for every benefit he received. He's paying a fair rent, he's paying a premium that perhaps reflects the surrender value, his share of the marriage value, but even so, because the effect of the granting of the lease was that there's a detriment to the freehold that is still in the hands of the landlord, it's treated as a transaction at an undervalue. And that brings me to the point about discretion.
This is a question of construction of 4231.
Yes, my Lord.
And it's clearly, I mean, on the sort of case we're talking about, it would be 4231C.
Yes, my Lord.
And the issue would be whether the value of the consideration given by the freeholder was greater than the consideration, or whichever way round it is. Sorry.
But the heart of it is the bank's case.
At the moment, see why they don't balance out.
The bank's case must be that the half share of the marriage value, which takes effect as a reduction in the value of the freehold,
all right. Well, we'll see it. Yeah.
Is a form of consideration, even though it's not something that ever arrives at the hands of the tenant, and nothing that you'd expect the tenant to pay for. But the diminution that's caused is, for these purposes, as I understand the bank's case, something which is treated as consideration that's being provided by the debtor that would weigh into the calculation under 4231C. If that premise is accepted, and we need to get to that stage, I accept, there would be this difficulty in exercising any discretion to solve the problem. Let's assume that the lease was granted at arm's length after commercial negotiations on what was genuinely considered by the tenant to be a fair market rent with a fair premium to reflect the surrender value. In that case, he would have acquired his property, the lease, from the debtor. So he could not be considered as a bona fide purchaser under section 4252A. That being so, in my submission, however broad or narrow one thinks the court's discretion is or should be, one thing it cannot be used for is to override an express limit set on a particular defence by the statute. The statute is as clear as day. You're not regarded as a bona fide purchaser. You cannot have a bona fide purchaser defence if you received property, acquired an interest in property, from the debtor. And so it does give rise to serious difficulties if the bank's case is right, and not ones that can be cured by discretion. And because leases are such common transactions, we're not talking about something that is out of the norm, incredibly unusual, exceptional. What we would be doing in those circumstances is simply deciding which defendants we like and which defendants we don't like. And in my submission, that is not the proper function of judicial discretion in this instance. My Lord, I'm trespassing beyond 3 o'clock, and so I should probably sit down. I will simply finish with this unless there are any further questions. In my submission, I don't have to say Mr. Appledolf was a good man. I don't have to say that everything he did was perfect. But if he had simply taken all of his assets to Belize or some other debtor-friendly jurisdiction where it's very difficult to enforce, no one would have said Section 423 applied. We can bring out emotive words like it being an injustice, but there are all sorts of injustices, in inverted commas, that Section 423 does not prevent, simply because one identifies on a particular set of facts something which is bad for a creditor does not mean it is within the terms of Section 423. And as my Lord Hamblin pointed out, the only authority apparently referred to by Mrs. Justice Gwyneth Knowles to support her conclusion was Feakins, which in my submission says absolutely nothing whatsoever to support that point. So, subject to anything the Court may have to ask, those are my submissions. And I'm very grateful to your audience.
Thank you very much. Mr. McGrath, there's been a focus in the final speech on the question of the lease. Would it be possible for you, having cleared it with the other side, to produce a one-page note on your response to that submission? That would be okay. Yes. Could you do that within 14 days?
Yes.
Thank you very much. There is one matter I would wish to raise at the end of these proceedings, and that concerns the requirements of Practice Direction 631. This provides that in drafting cases, the Court favours brevity, and the case should not, without the permission of the Court, exceed 50 pages. And in most cases, the practice note says fewer than 50 pages will be sufficient. The practice note also refers back to another practice note at 5 to 12, which specifies the font size and the spacing. In this case, the permission to exceed 50-page maximum was not given, but what happened with the appellant's case was the margins were narrowed, the gaps between the headings and the text were shortened, and footnotes in a lower-sized font contained argumentation. And there was also a shift, I think, in font use from Times New Roman to Arial, which expanded the number of words that were produced in the text. I have to say that is contrary to the spirit and perhaps the letter of the practice direction, and in future the Court will expect parties to edit their case when they've reached the limit. The Court has not in the past seen fit to put a word limit on the parties' written cases, but if there is a repetition of this, it will think seriously about so doing. Subject to that, it remains for me to thank Council for their submissions and those who have assisted Council in assisting us with this interesting case. The Court will take time to consider what is the appropriate outcome of this appeal. The Court will now adjourn.